Our next story deals with Google and the right to be forgotten. So, under EU law, there's a general law that allows you to submit that your information is so out of date and doesn't reflect who you are, and so a right to have search engines delist you. And so this has been an issue of controversy between the EU and US because the US does not have a similar law and has tended not to obey these decisions. And so the idea is, well, if the information is indexed in the US, then the information can still be found. So this has been a bit of a tension, and the courts have just ruled that this right to be forgotten only exists in the EU. So there is no right to be globally forgotten. So the US will remember. We remember all the things you do, and so we're going to read this decision and see what it has to say. The right to be forgotten online does not extend beyond the borders of the European Union. The bloc's highest court has ruled in a major victory for Google. The right enshrined in 2014 legal ruling required some search engines to delete embarrassing or out-of-date information, which requests the information be individuals concerned. But in a landmark ruling on Tuesday, the European Court of Justice said search engine operators face no obligation to remove information outside the 28-country zone. Perhaps soon to be 27, right? It, however, said search engines must seriously discourage internet users from going onto non-EU versions of the page to find the information. I'm sure the discouragement is going to be super effective. The balance between the right of privacy and protection of personal data on one hand and the freedom of information of internet users on the other is likely to vary significantly around the world, the court said in a statement on the decision. The right to be forgotten was not absolute right, the court said, and had to be balanced against other fundamental rights in accordance with proportionality. Privacy campaigners hailed a victory for global freedom of expression, while Google welcomed the court decision. The case originated in a dispute between Google and the French privacy regulator CNIL, which in 2015 called for the firm to globally remove links to pages containing dangerous or false information about a person. Google introduced a geo-blocking feature in 2016 following the year, which stopped European users from being able to see delisted links. However, it resisted censoring research results from other parts of the world, challenging a fine that they tried to impose. The technological firm argued that if the rule were applied outside Europe, the obligation could be abused by authoritarian governments trying to cover up human rights abuses. Google said it received 845,000 right to be forgotten requests in the past 5 years, leading to a removal of 45% of 3.3 billion links referred to in the requests. Although the content itself remains online, it cannot be found through search engines of the individual's name. The 2014 ruling related to a test case bought by a Spanish man after he failed to secure deletion of an auction notice of his repossessed home dating from 1998 on a Catalina website. Google won the backing of the ECJ's court advisor earlier this year, which said the right to be forgotten should be enforced in Europe only. Judges follow such non-binding opinions in 4 out of 5 cases. The U.S. firm was also supported by Microsoft, Wikipedia's owner of Wikimedia Foundation, and nonprofit Reporters Committee for Freedom of the Press, among others. Google had previously warned of the dangers of overreach of Europe. In a blog post 2 years ago, the company said there should be a balance between sensitive personal data and public interest, and no one country should be able to impose rules on citizens of another. Responding to the judgment on Tuesday, Peter Fleischer, Google's senior privacy counsel, said, "Since 2014, we've worked hard to implement the right to be forgotten in Europe and to strike a sensible balance between the people's right of access to information and privacy. It's good to see that the court agree with our assessment." Google and rival search engines will have to take measures, the ECJ said, to effectively prevent or at least seriously discourage users in the EU from using other versions. Thomas Hugh, executive director of the Freedom of Expression organization Article 19, described the ruling as a victory for global freedom of expression. Courts or data regulators in the UK, France, or Germany should not be able to determine the search results that internet users in America, India, or Argentina get to see. It's not the right of one country's data protection authority can impose on the interpretation of internet users around the world. So on the whole, I certainly agree with this decision, and I look forward to a special search engine that will be created for all the right to be forgotten requests. You just know that someone somewhere is going to create a database that just does nothing but index all the right to be forgotten requests, and so that you can search that specific index. So I look forward to righttobeunforgotten.com starting in the near future, which I'm sure is going to be a thing that happens in the US, so that should be super interesting when that occurs.